Personal Injury Law Show. This is a show that talks about everything in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years' experience. With me tonight, I've got a partner in the law firm, Nunzio Tartaglia, in insurance work.
Tony, Alice viewers, welcome.
And Alice Robinson, an associate in a law firm in insurance work. Good evening, Alice.
Tony, Nuns, nice to be here.
Viewers, tonight we're going to be doing an update on insurance law, so stay tuned for that.
Before we kick off though, Tony, what's in the news?
Well, viewers, there's been a lot going on in the world, and in particular, at home, hard times hit tradies. Now, what does that mean, Nuns?
Oh, basically, Tony, there's the figures are coming out, or the trend is that tradies are basically ending their careers earlier because of the hard toll of the physical labour they're doing, and it just brings into light the importance of making claims in this regard, Tony.
And also having appropriate insurance.
That's right.
Alice, is it harsh for me to say that a tradie's one bad accident away from retirement?
That's probably not too harsh, Tony. As you know, it is really physical labour, and quite often the circumstances can be dangerous. So I think it's interesting that these figures are coming out now, so we know a little bit more about what these people are in store for, and if you do have an inquiry, you should see a lawyer about a claim.
And not seeing that they're at greater risk than the average person in society, wouldn't you think they should get top-ups on their superannuation policies?
Oh, there's no doubt there's a range of insurance available to workers, particularly more labourers in this instance, because you've got income protection, trauma cover, CBUS, IncoLink. You've got a range of insurance schemes that they really should be applying for, because in the event they do get injured, you need to be protected. And a lot of them, unfortunately, aren't. When we see them come through the door at the firm, we ask the question, they just don't have it.
No. And Alice, the thing about top-up with CBUS, for example, you're allowed to buy units these days.
That's right. You can tell your superannuation insurance cover, or you can tell your income protection organisation that you want extra on top of what they normally offer. It doesn't usually cost much more in terms of the monthly premium, so it's always worth looking into.
Just another issue though with this, Tony, is that the article suggests that the workers are very stoic and they're not making the relevant complaints, and I'm sure there's a lot more potential work cover claims there, because they just haven't made the complaints to their employers, and also sought legal advice. So,
well, the message to the viewer then is make sure you lodge a complaint, that is, put in a claim, put in an incident report, just in case you have issues down the track, at least you're covered.
That's right.
Because you cover the issue of causation.
Yep.
Let's keep moving. The NRL has announced plans to increase their maximum insurance payouts to $1 million. Alice, this is on the spate of all the catastrophic injuries they've been getting.
That's
they had
right.
Steve McKinnon, who is quadriplegic.
Very badly injured,
And there's been a couple of others that have been very badly injured as well.
That's right.
What do you think about this?
Look, I think this is a good thing, Tony. The reality is that in a sport like the NRL, it is very physical and it can be dangerous for the players. And unfortunately, every now and then you're going to come across those catastrophic injuries like quadriplegia or paraplegia, or traumatic brain injuries as well, depending upon where you get hit on the day. And so I think it's a good idea that the insurance cover is expanding to accommodate that, because unfortunately medical expenses are a reality, to say nothing of loss of earnings. We're still trying to provide for a family at the end of the day.
I'm just surprised though that the NRL is so far behind the other codes, and if Alex McKinnon, who recently got injured, if this happened in the AFL, would have received up to $1 million as opposed to $500,000. So they're a little bit backward in my mind.
But even $1 million, if you invested in today's market, the highest interest rate's under 4%.
Yeah.
So you'd be getting a return of what? Not even 40 grand a year.
That's
It's
right.
not much.
It's not much in the larger scheme.
So, I mean, really, you've got to ask yourself, geez, you've got to have some sort of passion to be playing these sports.
Yeah, look, it's they're career-threatening and sometimes life-threatening injuries, and I understand on the weekend the Newcastle game, they contributed $5 to every ticket that was purchased, went to Alex McKinnon, which was a great cause, but should have never been in that situation in the first place for that bigger insurance payouts.
What about the North Melbourne player that came down on his head? He was very lucky, wasn't he?
Yeah, Lindsay Thomas.
Oh, yeah. What would he have got? Have they got a better cover?
Yeah, AFL about $1 million.
Okay.
Yeah, if it's life-threatening.
And this also picks up jockeys as well. They're in a very high risk category.
That's right, and you just got to be realistic about the risks of the game or the sport involved.
MH17, shot down by Russian separatists, who knows? Look, the sad thing about this case is there's going to be talk of compensation, and there's a school of thought that says you're not going to get over and above the statutory, under the Montreal Convention, the statutory minimum payout,
That's
185,
right.
Or are you going to be able to sue over and above that
Yeah.
because there was negligence on the part of the carrier? What's your view, Nuts?
Well, look, it doesn't matter what you offer these families. The money's not enough. 185,000 is trivial, really. But what I would be saying is that there's got to be another scheme where they do get compensated for more than this. And look, it's what they're alleging is that because it might be categorised as a criminal act, that there's no more compensation available, and that would be sad in this instance when all these families have lost so many innocent people. So either way, I don't think it's a good situation. I don't think the outcome's going to be pretty for anyone.
I'm just amazed that. Do you think we've done enough? I mean, I know it's political. I shouldn't really go into this, but it seems like a pretty soft sort of approach towards.
I think it's difficult, Tony, because civil aviation, as a general rule, whether it's an international or a domestic carrier, tends to be a matter of what they call strict liability, which means that if you've suffered the injury and you're in the right set of circumstances, in this case on a plane, then you will get a form of compensation with having to prove it's the airline's fault. What the paper has been telling us recently is that to get a bit more compensation or to get something over and above what everyone's going to get, you need to show that the airline's at fault in some way or another for flying perhaps over the wrong zone, and various other suggestions have been made in the article about that. But I think it is a really tricky area because of the circumstances, and at the end of the day it is a really, really tragic accident. And so, it's a matter of catering as best you can for those families.
But why can't you sue the Eurocontrol, the European Air Traffic Control Group, because they told the airlines they can fly over 33,000 feet, and under 32,000 feet's risky, but these air missiles, they could hit targets up to 50,000 feet. So I would have thought, why can't you sue them?
Well,
they gave them permission to fly.
Look, arguably, they're in the pun, they're in the gun, and then you've got obviously Malaysian Airlines. There's a lot of parties potentially that could be held liable. And look, I think this is going to be a long investigation that we won't get answers for a long, long time.
If you sued in Australia, you only get up to 500,000, I think. Is that correct?
Yeah, it's about it.
Yeah. Okay. Look, we'll come back to this, viewers. It's a very sad case, and it was really mind-boggling, and also just watching a family, the husband and wife sitting off those balloons the other day was just extraordinary.
Tragic.
I can't tell you. Woman sues over a dodgy treadmill. What's that mean, Nunz?
Well, woman stepped onto a treadmill and it sped up obviously without her knowledge, and basically shot her out, and she sustained a serious injury to her back, from what I understand. And look, she's now issuing proceedings over it and is seeking damages.
Look, I think, she has a good chance if she can show, Tony, that there's been some type of equipment malfunction that she could not have foreseen, and as long as she's using the treadmill properly, then she will be able to show that it's somebody else's fault that the injuries occurred.
I've had a few cases similar to this, to be honest, and so I'm not surprised that there's another one in existence. So.
And what's her claim worth, Nunz? Pain and suffering? Lost enjoyment of life?
Well, it sounds like it's a fracture of her lower spine. So it's and she's 61. So look, it's considerable.
Could be quite serious.
And there could be Gristle and Kirkmay in this?
Yeah, home help, and then you've got medical expenses, and I'm not sure if she was working, but if she was, she could also claim that too.
Okay. We've got to go to a sponsors break, viewers. Stay tuned. After a break, we'll take you to the update on insurance law. Viewers, welcome back to the show. Now, this is a must-see episode for grandparents and parents alike. Alice, we've got this case of Hoffman and Boland, New South Wales Court of Appeal decision. It's about a 6-month-old that the grandmother who was looking after her dropped her down a flight of the stairs. Can you give us the more extensive facts of this case?
Yes, thank you, Tony. So this case involved a family holiday, which included a young 6-month-old baby girl who was on holiday with her parents and grandparents. And I gather she was a little bit unwell on the night, and the grandmother at about 5:30 in the morning had picked her up out of her crib to take her for a walk to try and settle her down, and unfortunately fell down a flight of stairs in the holiday house, which I gather was owned by either the grandmother or the great uncle in this case. And unfortunately, the poor little baby sustained some seriously catastrophic injuries that she will carry with her for life. And she went on to sue the grandmother for breaching a duty of care because the grandmother had taken control of her or taken care of her whilst she was carrying her down the stairs. And there are a lot of complex facts in this case, Tony. For example, it came out in the evidence that the grandmother didn't turn the light on over the stairs when she went to walk down the stairs, presumably so she didn't
bizarre,
wake anyone up
really?
in the house. Yes, but it is a bit of a worry because it did end in this terrible accident. But unfortunately, the court found, whilst the grandmother has a duty of care, that her duty had not been breached in this case.
The builder was also joined in the proceeding, so there was also the builder as a defendant.
Yep.
No, this went to the Court of Appeal, where 3 judges heard the case. 2 of the judges agreed that there was a duty of care, correct?
Yep, that's right.
The 3rd judge said that there's no duty,
Yep.
right, for very strange reasons. What happened in relation to the issue of breach of duty?
Well,
That is, did she do something wrong,
Yeah.
which gives rise to damages?
Well, effectively, just 2 things. One, on the duty, the fact that it was a grandmother was a really bit of a furphy. Basically, the court said that the fact that the grandmother had control of the 6-month-year-old was enough to say that she had a duty. So whether it was grandmother or mother or whatever it is, that was just, I think that just goes into the facts. But in terms of the breach of duty, effectively the court found that what the grandmother did was reasonable in the circumstances. She put the bedside lamp on where the 6-month-year-old was laying, and also she was holding the handrail when she walked down the stairs. So basically they said she couldn't really do much more and to avoid the accident. So that's why eventually, obviously, the court found in her favour.
The court also said that if there was winders, there was an argument about winders.
Some type of safety measure, that's right.
What did you think of this decision, Alice? I mean, it's a bit harsh.
Look, it's a tough decision, Tony. It's a good decision in some ways because they found that grandparents can have liability or can have a duty of care towards children, a little bit like we hold teachers to the same kind of standard when the kids are at school and so on. But it is a tough case because the little girl did sustain some terrible injuries and she missed out on compensation because it was more about the facts and what was and wasn't done on the day. There were many parties joined to the litigation, including the building and construction company, and the court went through everybody one by one and found that everybody had done really the best they could and that they couldn't find any fault, despite the fact that that light didn't get turned on.
Yeah.
Do you think that the court knew whether there was insurance or not? Would she have been insured?
Look, I would assume she would have been because I don't think they would be suing a grandmother, because let's be honest, they're retired, not working, so I don't know if there'd be enough to cover a damages award. But I would have thought the court would assume, they wouldn't know, but they would assume that there's insurance. But I know the way I looked at this case, though, is that, you've sued the grandmother, but then you've also sued the builder.
They're complicated.
Yeah, to me, they're so distinct defendants that you sort of, it's like you're trying to just put everyone in one basket and
You
decide.
probably would have been better off to just chase the grandmother.
Sort of need to choose one of them.
Yeah. It wasn't like having a cleaning company and an occupier. It was so, I think, distinct that it just it
This is
confused
like
it a little
Alice's bets at the Melbourne Cup, 50 cents each way.
It's a bit like that.
Hey?
That's right.
She had 50 cents each way. It didn't work.
Never works.
and they all missed the place. Look, no one appealed to the High Court. Should they have sought special leave to appeal to the High Court?
Look, Tony, this one is a case where perhaps a different decision might have come out. We're never going to know at the end of the day, but I think it's always worth considering it, even if you don't.
I would have sought leave if they found that there was no duty. I would have sought leave.
Yes.
Next case. A steep driveway access should have been improved by the landlord, Panther and Piscetto, 2013 New South Wales decision. Geez, they litigate a lot up there, don't they?
It's the most litigated state in the country.
Nuts. What were the facts of this case?
Well, effectively, in this case, the respondent was staying in a self-contained flat owned by one of the appellants, and there was a steep driveway which obviously led to the flat, and in this instance, the respondent obviously slipped. And there were stairs, but unfortunately they were covered or covered in some way, so they couldn't use the stairs at the time. So slipping on the steep driveway, was that breach?
All right. You use the word appellant respondent. What you're basically saying, it's on appeal to the Court of Appeal.
Yep.
The appellant's a person that appeals to the court and the respondent's the one that's responding.
Yep.
Correct?
But the respondent in this case was the injured party, Tony.
So the injured party won the case in the first instance.
That's right.
The owners of the flat appealed to the Court of Appeal.
That's right.
What happened in the Court of Appeal, Alice?
So the Court of Appeal found that the owners were in fact liable, and Tony, I found this to be a really interesting case for a couple of reasons. The first is the court spent a lot of time describing the driveway and how it was built. So many driveways are just a flat concrete slab or a straight up concrete slab, whereas this driveway seemed to be large pebbles or rocks filled in by concrete. In the wet, it made it extremely slippery, and it was also very, very steep. And the court found that the owners didn't install a handrail, and also, as Nunzio mentioned earlier, the stairs were blocked off by some garden or hedge or something along those lines. And what the court said was this came down to the fact that the owners were renting their house out for a profit.
It was a commercial venture.
That's right. They were getting, I think they called it reward or profit, and also they found that it was a small thing to install a handrail given the dangerous sort of driveway and the fact that tenants wouldn't be familiar with the property as you only rent on a short-term basis, generally speaking. And so the Court of Appeal said, no, this injury is as a result of a breach of duty because it was small steps that the owner could have taken to fix the property up to be more safe, and they were receiving a profit for the rent. So
that's exactly right. Also, the other thing they said was that there could have been an alternative means of access because you had all these hedges and that in a way.
That's right.
And the test that the courts look at is they say, is the risk significant or insignificant? And was the risk of slipping on a steep driveway foreseeable? So if you can foresee these risks, you as a homeowner that's renting a property out are going to be found liable. On that note, viewers, we've got to go to a sponsors break. Stay tuned. We've got a couple more interesting decisions for you. Viewers, welcome back to the show. We're talking about a number of cases that affect everyone out there, that is, homeowners. Alice, there's a case of Johnson and another and Hancock where unfortunately the victim in this case passed away.
that's right.
Give us the facts. It's a very interesting case and it shows that you've got to be extra vigilant and cautious as a homeowner when you're inviting people on your premises.
So this case concerns a fellow who was carrying on a gardening and handyman business, and he had several regular customers for which he performed this type of work, and he was on the premises at a particular customer's house, and they had asked him specifically to trim a hedge and to plant some palm trees in the back. And while he was doing that work with an assistant, he unfortunately fell through a drain about 1 metre wide that had a very flimsy cover, and that was concealed from his view whilst he was performing the gardening work. And the court had some very interesting things to say about the homeowners and also about the previous owners of the property.
Okay. So viewers, the key to this case was the fact that there was a hidden trap which the poor deceased victim wasn't aware of. What did the court find, Nunz?
Well, at first instance, the court found in favour of the deceased or the dependent at the time, and in the sum of about $445,000. Basically, they said that the Johnsons ought to have known that the drainage pit was in existence and should have notified the deceased about its presence. And
Warn the deceased.
yeah, basically.
Yeah.
So, look, it was also then appealed by the Johnsons, and they were unsuccessful, and so the decision was upheld. So, look, I do think it was a good decision, to be honest.
I thought so too.
Yep.
So the key to it is this. If they had have advised the deceased that there was a hidden trap,
Yep.
which was the pit, and he still fell in, would they have got compensation, Alice?
Look, Tony, I think it would have been much more difficult in those circumstances because the court talked in this case a lot about the homeowner's duty to warn and duty to know about particular hazards on your yard, or on your premises. It's not good enough to say, oh, well, we were owners, we haven't owned the property long, we didn't know about it. And I think the court would have said, had the owners warned him about the hazard and he'd fallen in, they would have said, well, he's got to accept some responsibility. He had knowledge, and it's foreseeable that you might fall into a drain with a flimsy cover.
I still think the deceased could have won if they still warned about it.
It would have been like
just the contributory negligence.
Or they could have found it was just inadvertence, not.
Yeah.
That happens a lot on building sites. You know, a lot of people get injured at work where they know that there's a trap. The employer's done nothing to prevent or to protect the worker, and they still get injured, notwithstanding the fact that they know the trap's there, and the courts have turned around and said if it's inadvertence, you don't get punished for it.
That's right.
Although if you've done it that many times, there might be control.
Yeah.
Nunz, you run a pretty important insurance department at Tony Carbone, doing a lot of this sort of work. Assuming the deceased had survived and sustained serious injuries which required people to look after him at home, what would have been the entitlements to the family and him?
Well, that type of claim
services?
is what's called a Griffiths and Kirkemeyer claim, and effectively, if you can show that you need assistance for services that you used to perform yourself, you can get compensated for that, basically at about $30 an hour at the moment. So, if you need ongoing help for the remainder of your life, and 10 hours a week, 20 hours a week, whatever it is, it can be substantial compensation. And in this type of case,
millions of dollars.
Oh yeah, look, you'll find that in the sort of those really big severe cases, the home help's probably the biggest component of the damages. So this could have been quite substantial.
And medical treatment.
Yeah.
So. And Alice, in addition to that, there'd be also pain and suffering and loss of enjoyment of life.
That's right, and loss of earnings if you've been,
Past,
if you can show
present,
you
future.
were, that's right, earning money at the time of the
But
accident.
in this case, though, the deceased's wife effectively is making dependence claim. So she's lost effectively the value of him working and gaining that income. So that would, that's a sizable figure.
But Nunz, having said that, if he had to survive with these nasty injuries I'm referring to, it would have been a lot bigger payout.
Of course. That was
a
only
lot bigger.
That was only loss of earnings.
Oh, yeah. This could have run into the millions of dollars, correct, Alice?
It could have, depending upon how much care he needed.
Exactly. On that note, Alice, the viewers should make sure that they're insured.
They should.
And also, people that get injured in these sorts of circumstances should seek legal advice because, unless you get expert advice, you won't know, will you?
Well, Tony, next case is really on point about seeking legal advice because it self-representing yourself.
Okay, well, in that case, tell us about it. So Connell and Barnett, it's a Victorian decision 2014. Sadly, it's the only case that lost, but anyway, what are the facts, Nunz?
Well, effectively, this particular plaintiff represented herself in the County Court of Victoria and was unsuccessful at first instance, and then also appealed and was unsuccessful again.
Right.
And it just really shows the pitfalls of representing yourself because the litigation and the court system is quite complicated and one that requires expertise of lawyers.
That's a very important point Nunz made, but what are the facts, Alice?
Yes, Tony. So this case, it's a sad case. It involves an allegation of medical negligence against Barnett, who was a doctor. It's a plastic surgery case involving a procedure which the plaintiff undertook to correct some old surgery which she felt was a little bit unsightly, and she wanted a little bit more of cosmetic improvement. And really this case, Tony, came down to a fundamental argument between the patient and the doctor as to what was agreed upon before the surgery was undertaken. And the patient was adamant that she had agreed to a very small scar and an overall improvement, whereas the doctor said, no, I told you from the beginning what you were in for.
It was a state of knowledge.
That's right.
Yeah.
All about the state of knowledge.
But what really shot it down in flames in this case was the medical notes went in.
That's right.
Contemporaneous notes of the surgeon.
That's right.
Writing down what they discussed, and the court essentially said that they didn't believe what she had to say.
Like you said, contemporaneous notes. At the time of the consultations, he wrote notes obviously about what he advised her about the risks and what she may be left with by way of scars, and that type of evidence really cannot be beaten. And that's why, in any case, contemporaneous evidence is the most important and most valued.
And Alice, there was another important thing in this, where this lady had quite a number of surgeries.
Yes.
So the court said she'd have a pretty fair idea of the risks of, and the scars associated with surgeries, correct?
That's right. Look, the court held this particular plaintiff to a pretty high standard of knowledge, Tony, and made several comments along the lines of the fact that she was intelligent, that she had an idea of what to expect with a surgery because of her past experience. And they also noted that, unfortunately, with the evidence in the case, Tony, she picked out and emphasised the evidence that helped her, but completely ignored any evidence which she considered to be unhelpful.
She outsmarted herself.
Unfortunately, that's sort of what happened, and she really was that really was her downfall in the sense that when we're in court and we're dealing with evidence that's not helpful to our clients, the smartest thing to do is to get on the front foot and deal with it up front, because then the court don't feel like they're being deceived or that you're trying to outsmart the system.
Exactly. Nunz, anything else you'd like to add?
Oh, look, just my earlier point, Tony, just if
Get
you've got
advice.
potential action, you need lawyers because unfortunately, they just don't have the expertise to be in court, and that's what we're here for. So any assistance required, please call the firm at Tony Carbone.
Nunz, thanks for coming on board. Alice, good to get you back. Viewers, stay tuned for future episodes. Go to our Facebook, Twitter, YouTube, and always remember to stay safe.